ये मैटर जो मैं आपको बोलने जा रहा हूँ, आप इस मैटर को हमारे सॉफ्टवेयर पे टाइप करके आप अपनी मिस्टेक्स को जान सकते हैं और अपने शॉर्टहैंड को इम्प्रूव कर सकते हैं, जिसका लिंक मैंने अपने डिस्क्रिप्शन बॉक्स में दे दिया है।
Start. The investigation officer has filed charge sheet against the driver of the car as also the driver of truck. Stop. Spot investigation report establishes the fact that the offending truck was parked on the middle of the road. Stop. Undisputedly, accident took place at 9:30 p.m. and the truck is a heavy goods vehicle. Stop. Photograph of the place of accident substantiate that the offending truck was 14-wheeled heavy truck which was parked on the middle of the road. Stop. Though learned counsel submitted that the truck was parked on the extreme left of the road, however, perusal of the photographs would clearly substantiate the fact that the truck was parked on the middle of the road, and on the other hand, the learned counsel for the claimants submitted that there was fog at the time of the accident. Stop. There was no eyewitnesses to the incident. Stop. Taking into consideration the facts in totality, it may be stated that if the driver of the car was cautious, he would have avoided the accident, and accordingly the rule of last opportunity would be squarely applicable to the facts of the case, and therefore the finding recorded by the tribunal fastening 50% contributory negligence on the drivers of both the vehicles in question is just and proper. Stop. In view of the same, the finding recorded by the tribunal on issue number 1 is hereby affirmed, and the appeals filed by the insurance company challenging the liability are required to be rejected. Accordingly rejected. Stop. On going through the above extract from the impugned judgment, it is evident that the High Court recorded an affirmative finding that the offending truck was parked in the middle of the road. Stop. This finding, as borne out from the evidence, is not under challenge and has attained finality. Stop. The accident took place on 18/6/2013, which as per the Hindu calendar fell on Shukla Paksh Dwadasi, and thus there was not even a remote possibility that the road would be illuminated by moonlight at the time of the accident. Stop. The discussion of evidence by the tribunal and the High Court makes no reference to availability of street lights at the collision site, and hence there is no doubt that at the time of the accident the conditions on the road would have been pitch dark, making it virtually impossible for the incoming vehicles to sight the stationary offending truck within a reasonable distance. Stop. Learned counsel for the appellant urged that there is neither any evidence nor any finding by the courts below that the offending truck was parked on the road after taking due care and cautious, that is, either by switching on the parking lights or by putting any prominent markers around the vehicle so as to warn the passing vehicles. Stop. Apparently, thus the offending truck was left abandoned in the middle of the highway without taking due care and caution to switch on the parking lights or to put in place any other precautionary measures to warn the vehicles traversing the highway in the dead of the night. Stop. 22 persons stood accused of the murder of Krishna Ji and were tried by the Learned Additional Sessions Judge Bharatpur, Maharashtra in Sessions Trial number 20 of 2006. Stop. The Learned Additional Sessions Judge held 9 of them guilty of offences punishable under sections 148, 302 and 324, both read with section 149 of the Indian Penal Code 1860. Stop. They were sentenced to imprisonment coupled with fine. Stop. Aggrieved thereby, all 9 of them filed appellants under section 374 CRPC before the High Court of Judicature at Bombay, Aurangabad bench. Stop. Accused number 2 was the appellant in criminal appeal number 695 of 2008. Accused number 3 was the appellant in criminal appeal number 89 of 2009, and accused number 5 was the appellant in criminal appeal number 618 of 2009. Stop. A division bench of the High Court sustained the conviction of accused number 2, 3 and 5 and acquitted the remaining 6 accused on the ground that the charges leveled against them were not specific in relation to the injuries afflicted on the deceased and other injured persons. Stop. Both the appellants were incarcerated and remained in custody. Stop. It was only that this court directed their release on bail. Stop. In effect, the appellants have suffered imprisonment for over 10 years. Stop. The deceased, Krishnaji, and his family members, his wife, their son and their daughter-in-law and others were attacked by the accused with axes and sticks at the residence of the deceased. Stop. Deceased wife had lodged an FIR number 36 of 2006 was registered. Stop. The deceased was stated to have expired on the spot. Stop. His post-mortem examination revealed that he had suffered as many as 9 injuries. Stop. The cause of death was ascertained as head injury and intercranial hemorrhage with multiple fractures. Stop. 9 other persons were said to have been injured during the accident. The cause for the altercation was stated to be political rivalry. Stop. The deceased, as per his widow, was the sarpanch of the village about 15 years prior to the incident, and since then Ramji and Sambhaji, 2 of the accused, were on inimical terms with him. Stop. Thereafter, the wife of the nephew of the deceased became the sarpanch of the village, leading to further animosity. Stop. Significantly, both were the nephews of the deceased, being the sons of his brothers. Admittedly, at the time of the incident, there was a power cut due to load shedding, but according to the widow of the deceased, who was examined as PW1, there was sufficient moonlight to identify all the accused and the weapons that they used during the attack. Stop. 15 witnesses in all were examined by the prosecution to bring home to guilt of the accused. Stop. Documents and material objects were marked in evidence through them. Stop. The family members of the deceased were examined as eyewitnesses to the attack on the deceased. Stop. All 4 of them are closely related. Stop. The trial court, having placed reliance on the evidence of the witnesses, came to the conclusion that except accused number 1 and 2, none of the other accused participated in the assault on the deceased. Stop.